When it comes to medical malpractice, most people assume the rules are the same across the United States. But the truth is, malpractice laws vary widely depending on the state where the incident occurs. These differences can affect everything from when a lawsuit can be filed, to how much compensation a patient may receive, to the exact process required before a case even makes it to trial. In this video, we're going to explore in detail how malpractice laws differ by state, why these differences exist, and what they mean for both patients and healthcare providers. Let's start with one of the most important differences, the statute of limitations. The statute of limitations is the time limit a patient has to file a malpractice lawsuit after the injury or after discovering the injury. This window varies significantly depending on where you are. For example, in California, a patient generally has 1 year from the time they discover the injury, but no more than 3 years from the actual incident. In New York, the law gives patients 2.5 years from the act of malpractice to file a claim. Meanwhile, in Florida, patients have 2 years from discovery, but there's an overall cap of 4 years from the date the malpractice happened. These differences can mean that in one state a case is still valid, while in another state that exact same case might already be barred from ever reaching court. Now let's talk about damages. Specifically, non-economic damages, which include things like pain and suffering, emotional distress, and loss of enjoyment of life. Some states place strict caps on these types of damages, while others have no limits at all. California, for example, has long capped non-economic damages at $250,000, though recent reforms have increased that cap to $350,000, with plans for gradual increases in the future. Texas also enforces strict caps, with a $250,000 limit per physician and a maximum of $750,000 total per case. On the other hand, states like New York and Pennsylvania do not impose any caps on damages, meaning juries can award whatever amount they deem fair. This creates a huge difference in potential outcomes depending on where a case is tried. Another area where states differ is expert witness requirements. In malpractice cases, expert testimony is often critical because jurors need medical professionals to explain whether the standard of care was met. But some states go even further by requiring plaintiffs to include an affidavit or certificate from a qualified medical expert before the case can even begin. For example, in Georgia, when a patient files a malpractice lawsuit, they must include an affidavit of merit signed by a medical expert who states that the claim has a valid basis. New Jersey has a similar requirement, where an affidavit of merit must be submitted within 60 days of filing. By contrast, states like New York do not require an affidavit at the outset, though expert testimony is still essential once the case reaches trial. These requirements can add cost and complexity for patients trying to pursue claims. Some states also use pre-lawsuit screening panels. These panels review malpractice claims before they can move forward to court, with the goal of filtering out weak or frivolous cases. For example, in Indiana, Louisiana, and Nebraska, medical review panels are mandatory. These panels are usually made up of doctors and legal professionals who examine the evidence and give an opinion on whether malpractice likely occurred. Their findings are not always binding, but they carry significant weight in court. On the other hand, states like California and New York don't require these panels at all, allowing cases to go directly to court once they're filed. Another difference among states involves rules on joint and several liability. This concept determines how damages are divided when more than one defendant is found at fault. In California, for instance, doctors are only responsible for their proportionate share of non-economic damages. That means if one doctor is found 20% responsible and another is 80% responsible, each pays only their share. In New York, the rule is a bit different. If a defendant is found more than 50% at fault, that defendant may be required to pay the full amount of damages, regardless of the percentage of responsibility. This can significantly affect how cases are litigated, especially when multiple providers or hospitals are involved. Attorney fee limits are another area where state laws differ. Many malpractice cases are handled on a contingency basis, meaning lawyers take a percentage of any settlement or verdict. To protect patients from losing too much of their compensation to fees, some states cap attorney percentages. California uses a sliding scale, where attorneys can take up to 40% of the first $50,000 recovered. Then the percentage decreases as the recovery amount increases, dropping as low as 15% for very large awards. New York has a similar sliding scale, with fee caps ranging from 30% down to 10%. These rules are designed to ensure patients keep more of their compensation, but they can also discourage attorneys from taking smaller or more complex cases that are harder to win. Finally, some states provide special protections for certain healthcare providers. For example, Virginia has a state-backed malpractice insurance pool designed to stabilize costs and ensure coverage is available for providers. Florida places sovereign immunity caps on public hospitals, limiting the amount patients can recover when suing state-run facilities. In some rural areas, states also offer extra legal shields or incentives to encourage doctors to practice in underserved regions. These protections can make it harder for patients to collect large awards, but they are often justified as necessary to keep healthcare accessible in communities where providers might otherwise avoid practicing. So what does all of this mean? The state where a malpractice case is filed has a massive impact on the outcome. A patient in one state may have more time to file a claim, no cap on damages, and fewer procedural hurdles. In another state, that same patient might face a shorter deadline, a strict cap on damages, and mandatory panels or affidavits that add cost and delay. For healthcare providers, these differences can affect insurance premiums, the risk of litigation, and the overall practice environment. In short, malpractice law is not uniform across the United States. Each state has created its own system, balancing the rights of patients to seek justice with the need to protect healthcare providers from excessive litigation. Whether you're a patient considering a claim, a provider concerned about liability, or simply someone interested in how the legal system works, understanding these differences is key. The state lines don't just divide geography, they also divide opportunity, strategy, and outcome when it comes to medical malpractice cases. That concludes our detailed look at how malpractice laws differ by state. If you found this breakdown helpful, be sure to check out more of our content where we dive deep into legal and financial topics that affect everyday lives. And remember, the rules in your state matter more than you might think.